Before we start, I do want to say that I'm going to apologize. There's probably way more material in here that we can cover in detail. However, there is an attachment of a white paper that goes over a summary of most of the material I've covered today. So, and I will be around to answer questions. I have been in this game for a while. The book that you have in front of me, I co-authored, came out in January 2010. The first year the baby boomers hit 65, and we're still all waiting for them to transition. The issue here is that I talk about is a successful exit plan has to have two main components. First, the personal side for the owners. More deals fall apart, and we're going to talk about this, when the partners are not aligned in their goals. But they cannot align their goals until each founder does their own goals. So, obviously, everyone knows what a Monte Carlo analysis is. The issue, though, with the Monte Carlo analysis is the true story. I got a call from a client a couple of years back, mad as hell at me, saying, "You told me if we did this deal, I'd never run out of money." And I said, "That's true, but you didn't bother to tell the financial planner that you have a love for Italian sports cars and you would buy 4 of them in the first year after you sold the business." So when you are doing a financial plan, make sure you really question, someone's just written you a check for $5 million or $10 million. What is that pent-up demand for something special? That ski chalet in Denver, outside of Denver. What is it? Because it's going to blow your analysis and you will have very unhappy clients. So one of the things you do need to understand is focusing on that. We're going to spend some real time talking about income and estate tax planning a little bit later. Planning for the unplanned exit. What happens if you get hit by the proverbial bus? Do you have a management team in place? Does your family know what's going to happen? How are you going to deal with that? And we'll talk a little bit about the golden handcuffing of key employees and how to do that. Issues on family harmony. I tell people today with the estate planning part of my practice that there are 2 main issues. It's not what you leave your kids, it's how you leave it to them. Have you creditor protected? Have you protected it from divorce? And secondly, which is probably even more important, is making sure the Christmas dinner is as pleasant after you've taken that long dirt nap as it was before. Too many owners do not factor that in when they are looking at businesses, having people inside the business, having family inside the business, having family outside the business. I have seen the issues of putting children in debtor-creditor relationships is an awful situation. And also, when you have a family transfer, what is the real purpose in the founder's mind? I will tell you that generally when I see transfers, there are 3 types. One, basically the founder just wants to give it to the kid because he's worked there. Best way to probably do that is to have a note and have the note forgiven at death. And then if you want to equalize, you can do an equalization at that point. 2, you have the founder that says, I don't care about what happens to the money after I'm gone, but I want my income stream maintained. So setting up how you're going to maintain the income when you buy out. Is it a combination of interest? Is there deferred comp? Is there other factors that are going to go into the compensation to support the owner? What survives the owner death and can pass to the spouse? What gets wiped, what can get passed to the next generation? And so the third is obviously those that want to have a largesse that is going to go on to the next gen in some form, and how you deal with that in a family situation. Also, looking at concepts of, if this is going to be a home run, is this going to be intergenerational planning? Are you going to create intergenerational wealth? If you're going to create potentially intergenerational wealth, I would strongly advocate, and you'll hear later on my other reasons, that if you want to grow your business today, you really should be considering a C Corp. And clearly, the C Corp is the best way to accumulate intergenerational wealth, because with trusts, they pay a tax rate on ordinary income at $13,000 at 37%. Not a great place to put LLCs and S-corps. However, they do get the same favorable capital gains treatment as individuals. Great place to put C-stock. So privately held C-stock is a great place if you're looking that you're going to have an exit, looking at gifting as part of that planning. What are you going to do when you retire? I have this is another issue. I tell clients, don't tell me you're going to go play golf every day. Don't tell me you're going to work from home, because your wife and you will end up in a divorce probably. So what are you going to do at this time? And within that framework, one other question. A lot of times you can get a lot more money out of your exit potentially if you stay with the business. I caution founders about staying with the business in the sense of this has been their baby for so long. And I have a true story. My co-author, Dick Stiglitz, was a former Navy nuclear submarine officer. And he made the decision, probably cost him several $1 million, that he couldn't stay because he knew it would drive him absolutely to distraction to have someone else making decisions about his baby that he disagreed with. Part of a successful exit strategy is realizing, can you step away? Can you stay? I have seen a lot of bad situations of entrepreneurs staying longer than they should and it having a negative effect on the business, which could have a negative effect on earnouts, which clearly are more relevant today. Have you updated your estate plan? One of the things that I tell clients is, if you are the sole owner of the business, who is going to step in the day after the funeral and say, and act like Alexander Haig and say, I'm in charge? Because if you don't have that, it's Katie bar the door potentially, because that breeds a lot of insecurity. So one of the things that I talk about is if you do not have a management team in place, that you do pick one key employee, that you're going to make temporary CEO, even if it's the family that's eventually taking it over. Family's not going to be able to go in the week after the funeral and run the business but picking someone who's going to be able to go in, run the business in a fiduciary way to keep it going either for sale and or till the family can step in is a key piece. And I think a lot of estate planners miss the issue of figuring out who is going to run the company in a temporary basis. So these are things that you have to do on the personal level. On the corporate level, as I said, aligning the goals of the partners. If someone is looking for running a lifestyle business versus someone who is looking to run and grow the business, doesn't work real well. Okay, we run our Monte Carlo analysis. We find out, hopefully, we're positive. We can do all sorts of legacy planning, intergenerational tax planning, etc. But what do you do if you're negative? Can you do it through internal growth, or do you have to become a strategic acquirer? If you're going to become a strategic acquirer, do you know what you need to acquire to maximize value? Have you developed the SOPs needed to integrate that business? Because more M&A deals fall apart in the integration process. What can you afford to buy? And unless the partners are aligned on that, it's a problem. And I'll give you a worst successful story concluded in December. In 2015, I met with a family and did a perpetuation plan of transferring business from father to son. And one of the things I emphasize when you do this is, okay, we've taken care of dad now. How are we going to get you to that retirement level? Well, once we did that, we found another family in the same business in a close geographical area. And instead of doing an immediate merger, because I've lived by a philosophy my father taught me, which was I'd always be wishing to get in than crying to get out of a deal. And we all know of mergers that don't work. So the concept of what I did with these clients is we created a management company. The management company took care of all the centralized purchasing, G&A, everything ran through the management company. They kept their financials separate for this 12-month period. This way, they could also find out if they could play well in sandbox together. So at the end of 12 months, they did play well in the sandbox together. They threw their stock into the management company, completed the merger. We helped them acquire 3 more locations, and they sold in January for $22.5 million. My client, originally when I entered the business, was 1.5. His share was 8 million. So there is, by making sure that the partners are aligned in their goals and what they're trying to accomplish and where they're going, is so key. Now, other side, if you're selling your business, who's going to purchase it? Are you selling this to family? Are you selling it to management? Is it a strategic buyer? Is it a financial buyer? Each one of those will have different consequences on your management team. If it's a strategic partner and you're more of the junior, then your development and management team and retention of the management team is less important than a financial buyer or a management takeover and or family deal. Because this is one of the key issues that if you're going to do a family or management transition, getting the founder to do an honest assessment of what he does that no one else does in the business. Because if you don't understand that, you can't fill the holes that will be gone when that founder leaves the business. And the idea is to hopefully build up either internally or externally to hire someone to come in and fill those roles within the company. Because if you don't, then they're going to pay you less for your company because it doesn't run well without you. Another point I'm going to make to you, I was at a seminar about 10, 12 years ago with the head of Blackstone Acquisitions. And he put a question to the audience. He said, when are you going to sell your business? And he got everything from 1 year to 5 years and 10 years. And what he said is, you're all wrong. You're going to sell it when someone wants to buy it. Therefore, you always have to be ready to sell. Therefore, if you are at all contemplating that you would ever sell, build your due diligence library now. More deals fall apart when the owner is spending 6 months during due diligence not working on the business and doing due diligence. That's when the prices get haircut. So build your due diligence library. Complete buy-sell agreements. Partnership is like marriage without sex. The only thing that brought you together was create a progeny called the business. The only things you're going to fight about are money and control. Your buy-sell agreement is your business prenup. And it needs to be, and the fact is, it also is part of your potential prenuptial marital planning with spouses. In some jurisdictions, not all, there's something called equitable distribution, where a court in a divorce case awards the equity. They don't get into a buyout. The last thing most people want is to have their partner's former spouse as a voting member. So the idea of having spouses become parties to your buy-sell agreement in the case they are ever awarded equity, that one, automatically converts it to non-voting if there is a divorce, and secondly, has a buyout formula. You avoid having the courts getting involved. You also get something generally in that you're not going to get in a divorce situation, and that is you probably will be able to have some kind of note payment for the buyout of the equity, because it's the same note payment that would be applied to any other stockholder, so it's generally going to be awarded. Employment agreements are very key in most businesses. That's your most valuable asset, guys. How do you deliver that asset to the buyer? And we're going to spend time. Hiring, we know it's becoming harder and harder to hire. We also know it's more expensive to train. If you're going to grow, you need capital. This is why I'm going to be talking later, but I'm an extreme opponent, extremely in favor of the idea that if you're trying to grow and you're going to sell in the next 5 or more years, you probably should be a C corporation. Basic reason is that if you're trying to grow, you need after-tax capital. Corporations today have a 75% after-tax reinvestment rate, 21% corporate, federal, deductible state income taxes. If you are an S Corp or an LLC and you are beyond the QBI limitations, you're pushing 40, 45%, some states closer to 50%. So would you rather be reinvesting in your company with 75-cent after-tax dollars or 45-cent or 55-cent after-tax dollars? Plus, there's other reasons we'll talk about. But one of the issues of growing capital is to look at becoming a C Corp. Qualified retirement benefits. I have found that a lot of clients in the under 100 medical reimbursement plans are a real nice benefit that do not cost a lot of money to administer and help for retention. One of the issues, I do a lot of work in the body shop area. And in the body shop area now, one of the keys is getting a certification from like a Tesla. To be a Tesla certified shop, you are going to spend somewhere between $20,000 and $50,000 for equipment. You are then going to spend maybe $10,000 to train an employee. What we have started to do with a lot of the clients is putting in training agreements that says, we're training you, and if you do not stay, if you stay in the area and you go to work for a competitor, you're going to pay back part of your training bonus. It's not going to get rid of someone who wants to pay a $10,000 bonus to someone or really up their rates, but it's going to get rid of the tire kickers. Concept on the other side that we say, though, you stay out, you serve your 3 years, we pay you a bonus equal to the training that we didn't have to pay for that 3 years. And the push, usually the pushback I get from founders is, oh, my employees, they're going to have a problem with this. Well, my question to you, Mr. Employer, is do you want to train someone and spend this kind of money and they're not willing to commit that they're going to stay with you for 3 years? Who's looking at this in the wrong way? So looking at when you have to incur significant training, and this is not far, let's put it this way. I'm old enough to remember that a lot of the major brokerage houses had that kind of deal originally. When they got you your licenses, when you got your Series 7 and so on, if you left before a certain period of time, you'd have to reimburse them. So what is old is new again in some ways. You're finding more of that kind of work. Today, there has been a shift in the law with regard to covenants not to compete and their ability to enforce them against key employees. Most of the courts have held that that is a problem. However, what I believe is that if they're either an owner of actual equity or they are part of a phantom equity plan that says part of the purchase price is allocated to a covenant not to compete, that is completely enforceable. And by saying, I'm going to take 25% of whatever this bonus compensation is, I'm going to pay it to you over a monthly basis over the covenant period, you've created an enforceable covenant not to compete. Because the other side is that it says, if I think you're cheating, I pay it into escrow. Prevailing parties gets their fees paid. It's either a liquidating damage clause because it's not going to be the company using that as a funding vehicle. You're either competing or they're willing to take a risk that they're going to pay your fees. But it's a way to make sure that you've shifted the litigation risk on a covenant to the employee. And as I said, you can do that better with actual stock ownership and phantom plans versus options. Yeah?
So does that mean that you don't need a non-compete with a solid state owners plan?
Here's my comment to you. it's part of the stay bonus plan, is what I'm trying to tell you. The non-compete is part of the bonus plan.
So in other words, we're gonna give you this if you don't do this.
Right,
Okay.
exactly. And so you read the content of stay bonuses. In doing today, there are two types. I look at stay bonuses in two formats. There's the unplanned exit, and then there's the planned exit. With the unplanned exit, if you don't have a good management team, or you have a good management team but you don't have a lead, and you don't want to shift ownership, the idea of saying to these key employees, look, if God forbid something happens to me, if you'd agree to stay 12 months after my untimely exit, I will pay you a bonus of 50% of your W-2 income. That, to make sure you have a management team stays in place until you get an acquisition, makes real sense. It protects the family, protects the value. So the concept of making sure, and also by doing it in this stay bonus form, also something else. I think we all agree. Employees potentially get insecure if they think the business is going to be sold. Well, I live on the philosophy you can't get in trouble if you tell the story right. Instead, Mr. Founder comes in when he's initially going to talk about this and said, look, I met with the estate planner and he's all over me that I don't have something in place that if, God forbid, I get hit by a bus. And I want to put this plan in place. So you can effectively get them to the plan to a point without necessarily having them know that you're thinking about this in terms of a sale of the business as well. And again, figuring out how to best weed the employees. Metrics-based employees versus annual discretionary is probably relatively clear. Okay. The reason I'm a big proponent, one of the other reasons I'm a big proponent of C corporations is multiple classes of equity. You cannot have multiple classes of equity with an S corp. The problem you have with partnerships is that if you make that key employee an actual member, he is no longer an employee. He has to get guaranteed payments. He has to deal with his own self-employment taxes. That does not, employees tend to resist that idea unless you're going to pay the cost of them having to do that. But the LLCs does allow for multiple classes of equity. The good news also is that all three, there is no gain or loss recognized by a company when it sells its equity. S corps are primarily going to be phantom because of the two class of stock rule. The problem I have, to be honest with the term, is selling employees on a term called phantom. It's counterintuitive to say to them, oh, we're taking care of you in a phantom plan. So the other thing that I'm going to say to you is that another advantage of a C Corp is, how many of you have employers founders who are taking way more money than they need out of the company just because, that they don't really need that for their lifestyle? One of the advantages of C Corp is the founder can set up a non-qualified deferred comp plan for themselves. Can't do that with an S, can't do that with an LLC. So if you have, again, the tax play, if you have a choice of taking money out and reinvesting 55% of it, or potentially keeping 75%, reinvesting in the company in a non-qualified deferred comp plan that you'll be able to take out 5, 10, 15 years from now when you retire, potentially taking it out tax-free by borrowing a good chunk of it rather than even taking it out as an annuity. It's a great advantage for founders who are more looking at it at maybe not exiting, at basically being an absentee owner. And that's the other point, is, what is the owner going to really do? All right. If you're going to actually give out equity, I find it sort of nonsensical to say to key employees that I value your decisions, but I'm not giving you voting equity. So the concept of voting, but you can clearly make the buy-sell agreement where, I won't say it's completely illusory, but only certain decisions take a supermajority, and hopefully you've got at least one or two key employees who are always going to side with you to get, if there is a supermajority decision. Because the issue you have is that once you make them a partner and you go out and borrow $5 million in the company's assets, you're impinging their equity. So you do have to give them some potential say on large-scale transactions. Okay, if you don't sell the equity to them, and we're going to spend some time talking about selling the equity, you're going to give them the equity. Well, if you give them the equity, then you have a little problem called Section 83. Section 83 says that to the extent you have unbridled control of stock that is given to you, that is income to the fair market value. Well, it's a great present to give an employee stock that's worth $100,000 and give him $100,000 worth of phantom income. Not a real good, and no cash to actually pay the tax. So the concept here is that depending on the value of the business, we talk about potentially to knock down the value, putting a liquidation preference on the founders class, that we're going to sop out the first $1 million or $2 million worth of value on a change in control to reduce the overall value that would be going to this employee class of equity. So you can knock through liquidation. Obviously, also, we all know the concepts of minority discount for lack of control, lack of marketability. So you can knock these down, you can knock these percentages down, but in some form, either the employee is going to have to pay a tax on it, or he's going to have to defer it, which means that the equity he's not going to get his capital gains. Because that's the other problem that I will tell you with most stock option plans. And that is the employees say, oh, I'm going to get capital gains. Well, most of them don't have the money to execute their options prior to a change in control, which means they don't meet the 12-month holding period for long-term capital gains, which means they got ordinary income anyway. And so the idea of looking at stock options versus, as we're going to talk about, phantom plans where there's no content to the employee versus the sale of equity and how that plays out. Idea also is, though, that if you're going to give them equity, the idea of having some kind of vesting valuation. If they left at the end of 2 years, they get the higher of what they paid for the equity or 40% of the fair market value of the equity. So you ratchet up the value. The bigger piece that we do, though, is on the back end, and that is, if we're successful and we have converted 75% of what would have been ordinary income into capital gains by getting them stock, what we say to Mr. Key Employee is, in exchange for that, you're going to get only 10 or 15% of the sales proceeds at closing. You're going to get 60 to 70% at the earlier of 1 year after acquisition or 30 days after constructive termination. Change your job title, move you, etc. The balance is a funded covenant not to compete. Based on my conversations with investment bankers, I believe that if you can deliver an intact management team to most acquirers, you will end up increasing your EBITDA multiplier by anywhere from 25 to 100 basis points. Secondly is, you will also do something else. I think it's 62% of the deals that go to LOI do not close. The two major reasons are failures in due diligence, which is why I said you build your due diligence library before you start the process. And secondly, the greedy employee. Well, if you've got all your key employees already tied up, they can't mess up your sale. So tying up your key employees prior to the change in control so you can deliver them. And as I said, you now have changed because the fact is you're holding their money. In most cases, if you've paid them, you're suing them to get money back. You've shifted the litigation risk. This so improves the position. The acquirer likes this also because the fact is, if he doesn't want your key employee, he knows there's a funded severance package already there. On the other side of the coin, he's got 12 months to convince the key employees he wants to stay. And so looking at actual stock sale. Now, the way that I like to look at this is that once we establish a fair market value for the equity, that one, I think we'd all agree there are two types of employees in the world. There are those who are there for a paycheck, and there are those who are there for something else. Those who are there for a paycheck are not your management team because they will leave you for $1 more an hour. So, I do this to a point to test to make sure. And I say, Mr. Key Employee, I am going to sell you equity in the company for, let's say, 70% of its fair market value after discount, depending on what preferences and everything else. You're going to pay for this out of the after-tax discretionary bonuses I'm going to declare to you over the next couple of years. Zero-sum gain to the employee. But if the employee is not willing to give up the opportunity of a cost to become a member, an owner, then he probably shouldn't be on your management team. But the real key here is something else. This is actually a tax play. And that is, let's say there's $100,000 of discretionary owner profit. If the owner, let's say, is 45%, so he gets to get $55,000 of that 100. Alternatively, assuming the employee is in a significantly lower tax bracket, he pays 25% of that $100,000 in taxes. $75,000 rolls back into the company, and the employer then can take it out as a dividend, as a C Corp, at either at 19 or at 20 or 28, depending on how you want to play the game with taxes. So it's a way that you can actually, and the whole point of this is, guys, not giving the company away. The point is you need to figure out how much you can give, what you need to give away that's going to increase the value of the business more than what you've given away. It's not just giving away 20% of the company. It's figuring out, okay, if I give away 20% of the company, what does that do to my EBIT multiplier? And am I going to make more money when I sell it, giving this out, than not? And this is also where the liquidation preferences come in play also, because this is the way to say, okay, I brought the company to this level without you, Mr. Key Employee. I want that first. But I'm willing to make you a partner going forward in the profits. So the liquidation preference can serve the additional function of recognizing what the owner has put into the business prior to bringing on that key employee. So you want to look at those areas of how you can purchase this, how they can tie them in. Now, phantom, I like phantoms, except for the word, because they cost nothing to the company or the employee currently. It also has a fair amount of flexibility because it is, quote, phantom equity, but you can pay dividends to your employees or profit shares based on their award of equity units. You can potentially have conversion of those equity units on basic issues. You can have vesting valuation. You can, again, because it's a contract they're signing that says they're getting this discretionary bonus and part of it is being allocated to a covenant not to compete, that is completely enforceable. The idea and the point is that you need to factor this in because here's the other point, is if you do phantom or you do stock options, you have to be very careful. And that is the year in which they execute or you pay it is the year which the company gets the deduction. I've had unfortunately, I've seen situations where the tax deductibility comes in effectively the year after sale, and they have losses they can't utilize. So you need to plan with regard to how much deduction you may end up getting if you're going to do some kind of phantom or option plan, because you don't want to waste those deductions either. I am not a big believer, as I've already said, in stock option plans, because they don't, unless you're going to create an employee class of equity for the stock option plan, I'm not sure that it gains you anything. And as I said, if you're telling the employee you're getting stock, but unless you're going to give him the cash to exercise, he's still going to get ordinary income. So, you know, that's where part of the explanation of potentially of why you would use a phantom plan, explaining to an employee why you're doing a phantom plan over the option plan is because it cost him nothing to get in versus in a phantom plan, and he's getting this piece, versus in the options, he's going to have to come up with money, and he's going to have to come up with money 12 months in advance to get his capital gains. Yeah?
So, is it okay if I ask a question?
Oh, sure.
So, going back to the S Corp, C Corp thing, and then
Right.
the phantom stock, so what would force you to conclude that we're going to keep things as an S Corp and we're doing phantom stock?
Well, I'm going to get, that's the next section I'm going to cover. I wanted to make sure I covered the employee stock pieces first as new pieces. We're going to spend a chunk of time on S versus C and Y. But the whole point on stock options is you don't get, there's very little way to get capital gains treatment, and it's not in helping you with regard to covenants not to compete. Because the fact is, they're not going to be stockholders, probably. It's probably going to be a cashless exercise, so they're never going to be stockholders bound by it unless it's part of their employment agreement. And then you have the question is, will a court enforce it in their employment agreement? Oh, wrong way, sorry. All right. Corporate taxes, the 2017 Act with its shift of corporate tax rates to 21% and disallowing state income tax deductions for individuals has significantly raised the cost of, for it. QBI was put in supposedly to equalize. It doesn't because there are income limitations. The calculations are a nightmare to do. And when you reach a certain level, you're still going to be at 37%. And non-deductible state income taxes. So the question comes in is, Mr. Owner, you have one decision. Do you want to take out all the current income and live comfortably? Or are you willing to invest income in your business to grow it for a future sale?
Wait a minute, I mean,
Yeah.
this 37% you're throwing out here, why doesn't QBI knock that down?
It knocks it down to 29.6 first on a best case. However, phase outs, income limitations knock it out for a lot of people.
No, I mean,
If you earn over $457,000, it's gone in certain.
only certain professional service businesses. If you have a manufacturing company or construction company,
Okay, but
those income limitations don't apply.
all right, but you still have 29 plus non-deductible state income taxes. That puts you at 33 versus 25. It's still an 8% swing.
Hey, and what about double tax on the sale of assets?
We're going to talk about that. Okay? Okay, let's put it this way. This is not for everyone, all right? I am not saying that everyone should be a C. I'm not saying everyone should be an S. I am saying that anyone who has not evaluated their corporate entity since 2017 and how it plays together is potentially missing major tax planning. That's
It sounded like you were saying everyone ought to be a C.
no, it is clearly not. But what I'm saying is this is probably one of the big issues is, do you want to strip out all the cash, or do you want to have cash in your company to grow it? If you want money in the company to grow it, you're going to grow it more with 75% after-tax dollars in the C Corp than you are going to be stripping it out, paying the taxes, and then reinvesting in the company. You will be. So the question comes in, which are you going to do? If you want to maintain the lifestyle, I agree with you. QBI makes a lot of sense. It doesn't hit everyone, and it works well. However, go the other way, if you need investment capital to grow your business, it's still 8 to 10% of your net revenue growing.
Before we consider double tax on sale.
Let me get to double tax on sale, all right? All right? Also, if you're growing, you're going to borrow debt. Would you rather pay back debt with 75% after-tax dollars or lower tax dollars? I've had situations where you have clients that have an older founder. How are they going to accumulate the cash to necessarily take out that founder? This is a cheaper way to do it internally. Some business owners don't qualify for QBI. Some are hit by limitations on QBI. As I said, the issue of phantom versus actual equity is S versus C. S is a terrible vehicle for making gifting. If you want to gift the equity away, you can't put it in an irrevocable trust and not have all the income paid out. If you're trying to grow the equity, you want it to be in a C because the trust faces the capital gains tax. The only income it's going to have is sale of stock and dividends, so it's going to be far more favorably taxed if you're trying to do intergenerational transfers because you believe the equity is going to be more than what you need. ESOPs, owners of ESOPs, if you sell to an ESOP and you own C stock, you can defer by reinvesting qualified securities 90+% of the taxes. I have one client who's looking at it now. He doesn't need the income. He's going to do an ESOP. He's going to get $7 or $8 million. It's going to be, he's not going to touch, and his kids are going to get, and it's all going into a dynasty trust. Also, depending on where you are in the thing, qualified small business stock. Yeah.
So with that, though, you have to put it into specific types of securities like marketable
Yeah, exactly.
securities, or
Exactly.
can it be alternatives or not?
Let's put it this way. There are certain alternatives will qualify. Okay, I am not an expert on all of the qualified securities. I've done some work in it, but the basic idea here is ESOPs are great if you don't need the proceeds. ESOPs are not good if you want to live off the proceeds. It doesn't make sense to do an ESOP if you're living off the proceeds. But if you're not going to live off the proceeds, it's a great vehicle for a long-term deferral and buildup. Qualified small business stock is a great vehicle as well. Here's one planning tool that you can look at that is a little on the aggressive side, but I believe is acceptable, is that with qualified small business stock, it's got to be, quote, a startup. However, there is some law out there that appears to say that if you have an LLC and you do a recapitalization into a C Corp, that might qualify the stock for qualified business incomes for small business. And saving $10 million in potential taxes or 10 times your investment is a pretty good deal. As we talked about, other benefits is tax-effective giving. Certain defined benefit plans are more restricted in S Corps. Corporate, I have several clients who are making $1 million plus a year. They don't need $1 million plus to live on. The idea of converting a C Corp and putting $150,000 into a non-qualified deferred comp plan and paying the taxes on that currently and letting it grow as a form of additional pension plan is a wonderful vehicle for them. Significant savings we've talked about. A couple of other things. Currently, shifting of ownership. S corps have a way higher audit risk. LLCs have a higher audit risk than C corps, especially small C corps. So how aggressive you are. I have a lot of clients that like the idea of having a non-12/31 year end. Gives them some ability to potentially tax plan with their bonuses and carry back of losses. I will also tell you, talking to most bankers, it's easier for them to do a C loan than an S loan because the fact is they're more worried about the personal sides and the stripping out of money versus a C. So these are reasons to consider, and you have to evaluate a multitude of factors in this. Now, just show you just quick mathematically, QBI will produce the best result up to a certain point. Once you go beyond a certain point, it's far better for generating after-tax investment money. All right, double taxation. My comment to you is, if you do not have a client who has sophisticated enough financial projections to know what they are going to make by year end in December, then they have a big problem with their finances. So that's the first issue, is double tax should not be a problem if you have decent financial records. In November, you figure out what you want to bill out. You figure out what your average collections are. You figure out and say, okay, I want to accumulate $200,000 worth of cash for various purposes. So I'm going to take everything above $300,000. So I have my tax bill paid, or I should say, I guess it's $275, but in any case, I'm going to declare a bonus for the rest. Strip it out, no additional tax other than the self-employment tax, but versus having the additional $200,000 that was paid a significantly lower tax rate than it is in the corporation where it can be used, is not a bad thing. If you're over 25 million, you've got the accrual. Accumulated earnings tax, that's the one that seems to be a concern for that in my 40 plus years of practice, I have never seen a case on it. The whole concept is of accumulation within quote, corporations. My comment to you is very simple, is you can't get in trouble if you tell the story right. If you are accumulating money in your company and you put in your corporate minutes, I am accumulating this money over the next couple of years for these specific issues, these specific reserves, the IRS is going to have a hard time saying that was not a reasonable justification because it has it in the statute. Reasonable needs of the corporation. You just have to document it. You have to put that in your corporate records. There are significantly higher sales with C versus S. However, there are a couple of ways around that. First, personal goodwill is, I've had a lot of companies sold with a chunk of personal goodwill that are C corps.
So there's no employment agreement.
Let's put it this way.
There's an employment agreement, the goodwill belongs to the corporation.
The employment agreement, we're talking about the employment agreement for the founder.
Right.
The founder could have a new employment agreement with the acquirer.
No, you can't have one employment agreement for 20 years and change it 6 months before the sale.
Oh, no. First off is, my comment to you is that this needs to be done, if you're doing it right, 3 to 5 years before the exit, okay? You can't do it 6 months before. There are certain things you can pull off, but big issues like leases. If you are leasing the property, do not try to jump your rent 3 months before you put the company up for market. You know, there are certain things that you don't do. There's certain things also, as an example, that I'll point out that are real important if you're doing real estate. Rights of first offer versus rights of first refusal. Do never give a right of first refusal to buy your real estate. Only give a right of first offer, because no one will buy your real estate if it's under a right of first offer, a right of first refusal, because they're a stalking horse. And they know that the likelihood is they're not going to get it because someone else is going to get it. Right of first offer says, I'm ready to sell. We have the company independently appraised. Mr. Tenant, you can buy it at 97% of the appraised fair market value. Yes, no. If he doesn't do it, you're free to sell it. That gives them the ability, and you're saying, I'm going to recognize that there is no discount, there is no real estate commission, so I'll split the real estate commission. That's why I'm giving you a discount. But the idea of dealing with the transfer. But there are ways to plan around it. I'm also going to say something else, too. I'm finding that there is a lot less resistance to C Corps because I'm seeing a lot of PE firms are demanding rollovers, that they want a portion of the purchase price in a rollover, and having an entity to keep it in makes sense. So the idea here is that there are ways of structuring around it, and as I said, not all cases are the same. There is no universal answer, but I'm saying that if you have not looked at this area and your future, what your 5-year plan is, what your need for capital is, what your need to lock in your key employees, and how that's affected by the S versus C status in the last since the 17 Act, you're missing a major planning point. That's as far as I will go. It is not the panacea, and I stand where you are on that. Yeah.
Well, there was a question behind me too.
Sure.
So the general rule for C Corp planning is do it within 3 years before exit.
Well, there's another reason why you want 3 years before. And that is you can convert back after 5 years. And as an example, if you want to be an ESOP and you want the favorable tax advantages, the sooner you start it, the sooner that ESOP will then be able to roll back into an S Corp where it pays no tax on the other end. So the idea of starting as a C Corp earlier rather than later to be able to help your employees get a better deal sooner as far as no taxes on the S Corp is a worthwhile thing to consider. Yeah?
Can some of these strategies be employed after a partial sale of key employees of
Yes.
the existing S corporation?
Yes. I've done partials. We do some form of recapitalization, conversion, etc. The concept might be that, as an example, if you don't have vesting value, if you don't have a covenant not to compete in your equity, you might have to give a little larger percentage to the people who already had it to get them to agree to convert. That's the one problem, is it may cost you a few more shares to get there. Let me also, before I get to, I want to make sure I make one point, is that I see the market today is if you're going to sell next 2 to 3 years probably. I think if you do not sell, that in many industries, there is a ton of private equity and VC money out there buying up the mom and pop businesses. What will happen is, in 2 to 3 years, they will have their footprint in the major markets. Right now, they are paying unbelievably large prices. Those prices will drop once they've brought into the market, because then they can, once they're in and they've established themselves, they can open up shops by buying, don't have to buy existing shops. They can just brownfield them, as we call it, or just open up a new location. Therefore, right now, you have 2 choices. Grow, or decide your business is probably going to be a lifestyle business. Because that's really where you're going to be if you do not grow your business over the next 5 or 10 years. The way the market is shifting, it is highly likely that your business is a lifestyle business to that point because, yeah.
Well, I just have a comment, more or less, but selling to a private equity is kind of a pain in the ass, isn't it? It's just, I would rather do a strategic sell.
I have done my share of private equity deals. Some are easy, some are real difficult. The real advantage of most of the private equity deals is the roll in and roll out. The idea that they'll take a portion of the purchase price, put it in their equity, and every 3 years the private equity firm's going to roll out, and you get a chance to roll out with them, and if they've done their strategy right, you walk away with a lot more money. But they can be very demanding, and this is why I'm saying they are less concerned, as an example, potentially with your management team. So if you're going to go to a PE, but if you're going to go with a financial buyer or its management, you better damn well lock in your key employees, because that's really going to be how you're going to make your value in your business. Obviously, there's risks and changes in the law, but I will tell you, I think that we have seen that Congress has very little appetite to raise corporate tax rates much above 25%. That was the most Obama was going to allow, and I think that Manchin has made it very clear that he's not going to allow it. You're going to see more taxing on the individual level. I think that we just saw that in the new bill. I think you're going to see more of it. It's going to get more expensive on an individual level comparatively. Lastly, buy-sell agreements. How are you going to manage decisions between partners, especially once you bring employees in? What are the decisions that are going to require majority versus supermajority? You know, are you even going to give out enough equity where they're ever going to have, even the employees aren't going to even have enough to even kick you out on a supermajority? But the other point is dispute resolution. You do not want to have a long, arduous process that deals with dispute resolution. That destroys the value of the business. I mandate in my operating agreements and buy-sell agreements that there's 30-day negotiation between the partners if there's a dispute. If that can't happen, hopefully prior to signing the operating agreement, they have picked someone that they are comfortable with to basically play as mediator, that if one of them said to the other one, excuse the expression, you're full of shit, that they'd listen. Finally, it's a choice. Arbitration, or what I like is the reverse offer. If partners can no longer get along, the concept of saying, we're not going to be partners anymore, and I'll pay you X to buy you. I have now set the price. You have the ability to either buy or sell at X. It's a self-policing method to avoid litigation. I will also give you one other helpful hint in situations if you see things are starting to fall. Yeah.
The question on that method, how do you determine who makes the offer?
Whoever blinks first.
Okay, I didn't know.
You know, it's whoever blinks first.
I didn't say.
Whoever blinks first, and here's the other issue that you can do. If there's an economic disparity between the founders, you can build in that even though you pull it as the lower person, you get financing. So that the reverse offer is financeable under a set of terms in it, so you can't be forced out when someone knows you're in a bad financial position. So looking at that issue, rights of first refusal, everyone understands. Tag-along and drag-along rights. Tag-along is the one that's sometimes missed. That's the concept that Donald and I are partners. Someone comes to Donald and offers him $5 million for his 50% interest in the company. I look at him and say, there ain't no way I'm paying you $5 million for your company. But I like the concept. So what's going to happen is we're both selling. I'm going to get $2.5 million, you're getting $2.5 million, and we're both going to stay partners 25% with this guy. And he's going to now be the majority owner. It prevents sticking with an unwanted partner. In small companies, sometimes I also consider the concept is, as part of the right, that even if the company doesn't accept the right of first refusal, that the partners can vote and say whether or not a third-party purchaser will get voting rights. This at least ensures that hopefully when someone is selling to a third party, they're not going to sell to someone that their partners are not going to want to work with. So looking at that, another point is buy-sells. You do not, only in death and disability is there an automatic funding vehicle if something happens. However, when something happens, you want immediate control. So the concept of specifying that upon bankruptcy, death, termination, etc., that equity automatically becomes non-voting. And the company has a right to call the non-voting stock at any time. The issue is, obviously, it's appraised at fair market value at that time, so there's an incentive to probably buy it out sooner rather than later, but if the company doesn't have the cash, it's something to look at. Another point is, as I said, divorce. Also, I don't know if you've ever had anyone who's gone middle-aged crazy, but the concept of saying that if you leave the company and you do not give me proper notice of your leaving, 3 months, 6 months, etc., I get the right to haircut your purchase price because that's a bad act. You've hurt me, you've hurt the business. Same thing is true with fraud. Another thing to look at is, this is the estate retirement for the family. And I think we've all potentially seen situations where the value of the business was significantly higher the day before the person died than a year later, because they were the rainmaker. They were the one who really brought in the revenue. So what I build in the concept in buy-sell agreements is a concept of the corporation has the right 12 months after acquisition to have the company revalued. If the company has fallen off more than a mutually agreed on percentage, because we all agree business should fall off some, there's a reduction in the note. Because most founders would rather say, I'd rather see my family get a smaller payment than no payment at all, because 99% is going to my family and my partners are not going to stay at that basis. Another point in flexibility on the note, and that is cash flow. And the concept here is that, again, we want the note to get paid, but you don't want to kill the golden goose. So the concept of saying that I do this with monthly interest and annual principal payments. The reason why I do it on annual principal payments is your annual principal payment is the lower of level amortization, or what you would have taken out of the company had you still been a member of the company with all compensation frozen. So their way, effectively, the pain is shared. So if you were a 20% partner, your partner's comp was all frozen, your payment would be the lower of 20% of the profits of the company or level amortization. So this way, and if you have that, the note gets extended. But it's a way, again, of not crushing the company post.
Question for you.
Sure.
One of the things that I've seen we've put into some of these agreements is that those payments can't exceed a certain percentage of the company's EBITDA or EBIT. It's a very simple formula.
Similar concept to it works well in the S and C, in the S and partnership veins. In the C, your method works better in the C vein, okay. But in the S and LLC, you can point to the K1s,
right.
And that way you can So that's why I use that as the example there.
I mean that also you put that formula in there for the departures, whether it be voluntary or involuntary. In this.
Correct.
Modern age today, drug use is a thing. Even
Oh, yeah.
Very, very successful business owners.
It's cause. To me, that's in my agreements that it is. If substance, use of prescription or non-prescription drugs that has a negative impact on your ability to perform your services is grounds for termination. However, on the other side of the coin is, only violent and financial felonies count for cause because I do not want a DUI necessarily to be treated as cause for termination. So it's, again, the balancing act of the practical sides of the law versus the practical sides of trying to protect your employees and protect your business. Last point is funding is how you are going to fund, if you are going to fund with insurance, how you're going to fund it. Is it going to be cross-buy? Is it going to be corporate-owned? Is it going to be held by a trust, which is where it is held by a trust, each of the employee, the trust pays the premiums, the trustee collects the death benefit, exchanges it with the family member to get the stock from the deceased family, and you take out the interpersonal portions that can sometimes happen if money is changing hands between former partners, etc. There is some advantage to having an independent person do that where they're not coming in and there isn't that chance for the fight. So I'm a big believer in it. Plus, with what we're seeing today in the corporate minimum tax that they're talking about, though it is only hitting on the higher ends, one of the major issues in corporate minimum tax is the book tax difference. Well, life insurance premiums going into a company is a book tax difference, which means you've just increased the value of your business for estate tax purposes, because the IRS is going to say that death benefit is part of your estate, and you may have increased the corporate income tax on the company because of the book tax difference, depending on the size of the company. So that's why I tend to believe in the trust. Cross ownership is not bad, except you always have this comment of saying, that's fine, except what happens if I have a fight with my partner and I walk behind his car?
What would you use a life insurance LLC?
Life insurance LLC would be the same thing as losing a life insurance trust. Same concept. The only reason why I like the trust better is the fiduciary duty of the trustee, and it's usually someone who is not one of the partners. And it's again, this is usually, some of these situations are highly wrought, and sometimes it is better to have someone independent come in. And that's a point that I want to make about something I said earlier about aligning the goals. You need someone, and I don't care which professional. I'm a big believer in the team concept. I work with a lot of different professionals in a lot of different ways. But you are doing your client a disservice unless you have a facilitated discussion between partners as to the 5-year plan, their relative roles in the business, etc. You need to have that. But that happens only after each side has done their personal side, so they can advocate for themselves on the personal side. But once you do that, you have the chance of making this a successful transition. And with that, I thank you for your attention. I hope you found it worthwhile. And I'm around the rest of the seminar for questions.